Okay, so let's unpack this. Imagine a contract is like a recipe.
A recipe.
Yeah,
I
a
see.
recipe. There is a very big, very important difference between promising someone, I will bake you a cake, versus saying, I will bake you a cake on the condition that you buy the flour.
Oh, absolutely. It is a massive difference.
Right. It sounds like a tiny, almost invisible change in phrasing.
Yeah.
But legally, that little shift, well, it completely changes the game. So welcome to the deep dive.
Thanks for having me.
Today, we are looking at a stack of legal briefs, case law, and contract outlines to really demystify the hidden tripwires in our everyday agreements. We're looking at contract law, specifically the difference between what you promise to do and the conditions that actually force you to do it.
And it is such a vital distinction, because you enter into contracts all the time. I mean, you sign an apartment lease, you buy a car, you click agree on a new app, or you accept a job.
Oh yeah, constantly. We agree to stuff every single day.
Exactly. But what actually lets you off the hook if things go wrong? That is what we are going to decode today, just using simple, everyday English. And honestly, that cake recipe is the perfect starting point to understand the core theme here.
I thought it worked pretty well.
It really does. If you make a firm promise to bake a cake and you fail to do it, well, you have broken the deal. Legally, that is a breach of contract, and you could be penalized.
But what if it was phrased as a condition?
Right. If your baking was a condition, meaning it depended on an uncertain future event, like the other person buying the flour and they never actually buy the flour, well, you didn't break a promise at all.
Because the trigger never happened.
Precisely. Your obligation to bake simply vanishes entirely.
Your legal duty just evaporates into thin air.
I love that. So before we figure out how these agreements fall apart, we really need to understand how they're built in the first place. Like, why do courts and judges care so much whether a sentence is a guarantee or just a trigger? Well, they care because it dictates whether someone pays a hefty penalty or just gets to walk away clean. A condition is simply a future uncertain event.
Okay, an uncertain event.
Yeah. And when that event happens, it does one of three things. It either creates a new right, it destroys an obligation, or it expands a duty.
But what if it's confusing? Like, what if the contract is written terribly?
That happens a lot. If an agreement is blurry and a judge can't quite tell if a sentence is a promise or a condition, the court will usually assume it's a promise.
Really? Why is that?
Because courts generally prefer to keep contracts intact rather than just having them vanish on a technicality.
Yeah.
But when conditions are clear, they basically come in two main flavors. You have express conditions and you have implied conditions.
Okay, let's start with express conditions.
Yeah.
These are the literal, explicitly written rules, right? Like, the contract will literally say words like on condition that, or, provided that.
Yes, exactly. And these must be complied with literally. There is no wiggle room.
Arbitration clauses often fall into this umbrella too, don't they?
They do, yeah.
Those are the clauses that force you to settle disputes privately outside of public courtroom. Though, I mean, a judge will step in if a regular consumer is unwittingly signing away massive fundamental rights.
All right. Judges do have some limits on what they'll enforce against a normal person.
But here is where it gets really interesting to me. Say I tell a painter, I will pay you, provided that you paint my house blue. That is an express condition. But what if they use a slightly different shade of blue, like a nice navy instead of cobalt? Does the whole contract just explode?
If the language is truly explicit, yes, it actually can.
Wait, really? Over a shade of blue?
Yes, because the law says express conditions must be strictly enforced. If the exact condition is not met, your obligation to hand over the money just does not trigger.
Wow, that is harsh.
It is. Now, courts won't enforce them if the language is buried or confusing, like we said. But if it is crystal clear, exact compliance is required. You didn't get cobalt, you don't pay. But you have to contrast that strictness with the second type, which are implied conditions.
Okay, so implied conditions aren't explicitly written down, but they're presumed to be part of the deal.
Exactly.
And there are a couple of ways things get implied, right? You have conditions that are implied in fact, which is when it is blatantly obvious both people meant to include it but just forgot to write it down.
Right, like an oversight.
Yeah. And then you have conditions that are implied in law, sometimes called constructive conditions, where a judge basically steps in and says, look, this rule isn't in the paperwork, but it's just what is fair and reasonable for this situation.
Let's look at a classic historical example of a judge doing exactly that. Imagine a banquet hall is rented out for a wedding. But tragically, before the wedding day, the building burns to the ground.
Oh, that's terrible.
It is. Now, the paperwork might not explicitly say, we will pay you on the condition that the building still exists. Nobody writes that.
Right, you just assume the building will be there.
Exactly. So the law implies the hall's physical existence as a basic condition of the agreement. Since the hall is gone, the condition fails, and the person renting the hall is totally excused from paying.
That makes total sense. And judges also supply implied conditions for everyday exchanges, don't they? Like, if you
Yes.
hire a builder, the law implies they have to actually do the work first, at least mostly, before you have to hand over the money.
Yes, that is a huge one. And there is also a legally implied duty that you actually have to cooperate with each other to get the job done.
Like, you can't hire a builder and then refuse to let them onto your property.
Exactly. That implied duty to cooperate is crucial. And notice the difference in strictness here. With these implied conditions, the law doesn't demand absolute perfection like it does with express conditions.
So close enough actually works here.
Yeah, doing the vast majority of what was asked, what the law calls substantial performance, is usually enough to satisfy an implied condition.
Okay, so just to make sure we are fully tracking this before we move on, let's do a quick recap. Conditions are essentially if-then triggers, while promises are strict guarantees. Express conditions are written in stone and need an exact match, while implied conditions are filled in by common sense or a judge, and usually just being close enough is totally fine.
That covers the building blocks perfectly.
Awesome.
But, knowing what these triggers are is only half the battle. We also have to look at when they happen, because timing completely flips who has to prove what if a dispute ends up in front of a judge.
Timing is everything. Legally speaking, timing acts kind of like traffic lights. You have conditions that act as green lights and conditions that act as red lights. These are known as conditions precedent and conditions subsequent.
Right, let's translate those into plain terms for everyone.
Right.
A condition precedent is an event that must happen before your duty to do something even begins. Think of the word precede.
Okay, so it has to happen first.
Exactly. If a deal goes sour and we end up in court, the person who is suing, the plaintiff, has the burden of proving that this starting event actually happened.
Makes sense.
On the other hand, a condition subsequent is an event that stops or discharges a duty that you already had. In court, the person defending themselves has to prove this stopping event happened so they can avoid being held liable.
There is a fantastic example from the legal notes that perfectly illustrates how this works in real life. Say person A hires person B, but only if person B passes their big licensing test, like a lawyer passing the bar exam.
Right, a classic scenario.
Meanwhile, person B really needs to pay the bills, so they take a temporary job working as a clerk for person C, and they agree to do that clerk job until they pass the bar exam.
What is fascinating there is that we are looking at the exact same event, passing the bar exam, but it functions completely differently in the two separate agreements.
Exactly. Passing the exam acts as a green light for the new job with person A. That's a condition precedent. The job doesn't start until the test is passed.
Right.
But that exact same test is a red light for the temporary clerk job with person C. It's a condition subsequent. The obligation to work as a clerk just stops the moment the test is passed.
And that timing dictates the courtroom strategy. If person A refuses to hire person B has to show up to court as the plaintiff and prove they passed the test to force the hiring.
Because it's a green light. They have to prove the green light turned on.
Exactly. But if person C tries to sue person B for quitting the clerk job, person B is now the defendant, and they have to prove they passed the test to justify walking away.
To prove the red light turned on.
You got
Let me synthesize this real quick to ensure we have it locked in. A precedent condition acts like a green light that starts a legal duty, and the person suing has to prove it happened. A subsequent condition acts like a red light that stops an existing duty, and the person defending themselves has to prove it happened.
Which naturally raises the next major issue. Who actually gets to decide if a condition has been properly met?
Oh, that's a good question.
Yeah, we know the timing, but how do we know when we've actually crossed the finish line? This brings us to how the law judges satisfaction.
Because saying a job is done can be incredibly subjective, right? The law splits this into two different ways to measure satisfaction. You've got the objective test and the subjective test.
The objective standard is the default. This is based on what a hypothetical, reasonable person would think. The law prefers this standard for normal, non-unique goods or standard workmanship.
Like fixing a roof or something.
Exactly. If you hire someone to pave your driveway and they do a structurally sound, totally normal job, you have to pay them. You can't refuse to pay just because you don't love the exact texture of the asphalt.
Right, a reasonable person would say a driveway was paved, so the job is done.
Yes. But then you have the subjective standard, which is entirely about personal aesthetic taste.
If I hire you to build a standard fence, a normal person can look at it and say, it's fine. But if I hire you to paint a portrait of my family, well, I am the only judge. My personal satisfaction is the only thing that matters because art is totally subjective.
It is, but the law doesn't give you a blank check to be unreasonable. There is a major guardrail here called the good faith exception. Even with art or personal taste, your dissatisfaction must be honest.
Wait, so if I hire you to paint that family portrait, I can't just lie and say I hate the painting simply because, I lost my job, went broke, and realized I just can't afford your bill anymore.
No, you absolutely cannot. If dissatisfaction just to avoid paying is actually a breach of contract in itself, it is a failure to act in good faith.
That makes a lot of sense.
And, speaking of the mechanics of paying people, we should clarify how the law treats time of payment clauses.
Oh, this is a huge trap for freelancers.
Hmm.
Sometimes a contract will say, I will pay you when I get paid by my client.
The dreaded paid when paid clause.
Yes. And people might think that is an absolute condition, that if the client never pays, they never have to pay the freelancer. But courts usually view this simply as a helpful guide for when payment is expected, not an absolute strict condition that cancels the debt if the event never happens.
Because courts generally do not want people to do hard work and get absolutely nothing just because of a technicality in the payment schedule. They will interpret it as a timing mechanism, meaning you have to pay within a reasonable time regardless of whether your client actually paid you.
Okay, pulling this section together. When it comes to deciding if a job is done, everyday goods and services use a normal, reasonable person standard. But art and personal taste use a subjective personal standard. However, even if you are the ultimate judge of the art, you still have to be totally honest about whether you like it or not.
Spot on. Which transitions us to a massive divide in contract law. Everything we have discussed so far has mostly been about services, painters, builders, clerks. But what happens when you are not hiring a person to do a task, but instead you're just buying physical items?
Wait, so the rules for services don't apply to physical goods. Why the sudden shift in how the law treats them?
Well, when dealing with services, as we established, the general rule is substantial performance. Close enough, basically.
Right.
If a builder makes a minor mistake on a house, you still have to pay them the contract price minus whatever it costs to fix that minor flaw. You can't just refuse to pay the whole bill. The law recognizes that human services are messy and often, permanent.
But that leniency vanishes when we transition to the sale of physical goods. The sale of goods is governed by a uniform set of commercial rules. And under these rules, substantial performance is not enough. The law requires perfect tender.
Exactly. And why the law shifts is purely practical. You can't exactly unbuild a house that is sitting on your land, but physical goods are movable.
Okay, so give me an example of perfect tender.
Let's say a clothing store orders 1,000 blue shirts from a factory, and they receive an order of 999 blue shirts and one single navy shirt. The factory did not provide perfect tender.
Wait, perfect tender. Under that rule, can the store legally reject the entire massive shipment over that one single wrong shirt?
Yes, they absolutely can. The delivery must be exact.
That is wild.
It seems extreme, but think about why. The factory can easily take those shirts back, put them on a truck, and sell them to someone else. It's not permanently attached to your property like a house.
I see.
However, the law does offer the seller a bit of a lifeline. If the buyer rejects the goods and there is still time left on the original contract deadline, the seller has the right to cure.
What does that mean, to cure?
It means they can rush over and swap out that one navy shirt for a blue one before the clock runs out on the contract.
Okay, that makes the harshness of perfect tender feel a bit more logical. Now, when selling goods, there is also something called a warranty of title. Basically, the seller is automatically promising three things. One, that they actually own the item. Two, that they have the right to transfer it to you. And three, that there are no secret security interests or liens on the item that you don't know about.
Exactly. And if a seller wants to avoid making that promise, they have to use incredibly specific language to disclaim it. You can't just sell someone a stolen car and hide behind vague contract language.
Good to know. So we have these strict rules for perfect goods and clear ownership. But how do these goods actually get handed over?
Yeah.
I read that if the contract doesn't explicitly state the delivery rules, The law steps in and fills in the blanks for how to tender or deliver the items.
It does. If the contract is totally silent, the default rule is that delivery has to happen within a reasonable time in one single delivery, unless it's something massive where you clearly don't have the storage space to take it all at once.
And usually the handoff happens at the seller's place of business.
That's the default, yes. But there are 4 recognized ways to deliver goods, and they each handle the mechanism of risk completely differently.
Oh, risk. Like, who pays if the truck crashes?
Exactly. So the first way is what you just mentioned, at the seller's place of business. The seller's only job is to put the goods aside, make them available, and notify the buyer to come get them. The risk shifts to the buyer once they are notified.
So if it gets damaged in the seller's lobby after the buyer was called, that's the buyer's problem.
Usually, yes.
Wow. Okay, the second way is a shipment contract. Think of this like handing off a baton in a relay race. The seller drops the goods off with the shipping company, makes a proper shipping contract, hands over the tracking documents, and notifies the buyer.
Right.
The moment that package is with the carrier, the seller's main legal job is done. If the delivery truck crashes on the highway, that is now a problem between the buyer and the shipping company.
Which is very different from the third method, a destination contract. This is much stricter for the seller. A destination contract means the seller is on the hook until that package physically hits your front porch or whatever specific location was agreed upon.
So the seller holds all the risk during transit.
Exactly. They hold all the risk, and they have to hold the goods at the destination and give you notice.
And the fourth way is when the goods are sitting in a third-party warehouse. The legal term is a bailee, but it's really just someone holding the goods.
Right. A bailee just means a warehouse or storage facility.
So to deliver them, the seller doesn't even have to move the boxes. They just have to give the buyer the official title documents or get the warehouse to acknowledge that the buyer is the new owner.
Yep, it's just a paperwork transfer. And once the seller successfully executes any of these 4 methods, the buyer has an absolute legal obligation to accept the goods and pay for them. Though they do always retain the right to inspect them first to ensure they meet that perfect tender standard we talked about.
Okay, let's recap this crucial shift. Service contracts allow for almost perfect work, where you just deduct the cost of minor mistakes because you can't unbill the service.
Right.
But buying physical goods demands absolute perfection, known as perfect tender, because goods can be resold. The rules also enforce strict guarantees that the seller actually owns what they are selling and provide clear rules for who holds the risk during delivery.
Perfect tender sounds incredibly harsh, and, well, it is. Which brings us to the loopholes.
I love a good loophole. Are there any ways these strict conditions just magically disappear?
There are. There is a massive exception to the perfect tender rule, and that is installment contracts. If the agreement is designed so that the goods are delivered in multiple separate shipments over a long period of time, the perfect tender rule is thrown completely out the window.
Wow, just completely gone.
Completely gone. It is replaced by a much more forgiving standard called substantial conformity.
Close enough is back.
Close enough is back. And think about it practically. If you are a factory receiving shipments of raw materials every single month for a year, you cannot reject a single delivery just for a tiny, insignificant flaw. You can only reject that specific monthly delivery if the flaw substantially hurts the value of that one shipment and absolutely cannot be fixed.
And you can only cancel the entire year-long contract if that one bad shipment is so terrible that it ruins the value of the whole entire deal.
Right.
It makes perfect sense. The law doesn't want a long-term business relationship destroyed over one tiny shipping error in month 4.
Exactly. Now, beyond installment contracts, there are 4 specific ways that conditions of any kind can be entirely suspended or excused. If a condition is excused, the person who is protected by it loses that protection and can never use it as a defense again.
Okay, let's break these 4 down into simple terms. First is waiver. This is just letting it slide.
Basically, yes.
If you say or act like you don't care about the condition anymore, you have waived it. You can sometimes change your mind and take that waiver back, but only if the other person hasn't already heavily relied on your waiver to their own detriment.
Right. If they've already spent money based on your waiver, you can't take it back. The second way a condition vanishes is through wrongful interference. Remember earlier when we mentioned the implied duty to cooperate?
Yeah.
If you actively sabotage the condition from happening, the condition is entirely excused, and you absolutely have to fulfill your end of the deal anyway.
I like to think of wrongful interference like telling a teenager they only get paid $10 on the condition that they mow my lawn. but then I intentionally lock the garden gate and hide the key so they physically cannot get to the grass.
That's sabotage.
Exactly. I sabotage the condition.
All right.
So the law says I still owe them the $10.
That perfectly captures the mechanism. The third way is called election. This simply means that if a condition is broken, but you choose to just keep moving forward with the contract anyway, you have effectively elected to waive that condition.
So you can't suddenly complain about it months later when it's convenient for you.
Exactly. And the fourth and final way is estoppel. It's a heavy legal word, but in plain English, it just means you tricked someone.
Trick them how?
Well, if you make someone believe that a condition won't be enforced and they reasonably rely on that impression, you are estopped or legally blocked from suddenly using that condition as a defense later to get out of paying.
It all comes back to a core philosophy of fairness, doesn't it? The legal system will enforce strict rules, but it will not let you use the mechanics of contract law to lay traps for people.
Absolutely not. Judges hate tricks.
Let me do our final recap to lock this all in. If a contract for goods is broken into multiple long-term deliveries, the harsh perfect tender rule is replaced by a more forgiving close enough standard. Furthermore, contractual conditions can completely disappear if you waive them, if you actively sabotage them like locking a gate, if you ignore a broken condition and keep working, or if you trick the other person into thinking that the condition doesn't matter.
That covers the deep architecture of agreements. And honestly, knowing the difference between a guaranteed promise and a flexible condition empowers you in every single agreement you make.
It really does. From hiring a contractor to fix your roof, to buying a car, to accepting a new job, you now know exactly when close enough is legally valid and when the law requires absolute perfection.
And you know who has to bring the receipts to court, and how your own actions, like locking that garden gate, can legally bind you.
Right, because knowledge is most valuable when it's applied to your daily life. And since contracts are everywhere, these rules are constantly operating in the background of your life.
Always.
Which leaves me with a final slightly terrifying thought for you to mull over. Think about those massive 100-page digital terms of service you blindly click agree to every single day on your phone.
Oh, we all do it.
We do. But based on what we just learned about express conditions needing strict literal compliance, what impossible conditions have you already legally bound yourself to without realizing it? And if a giant tech company makes it impossible for you to use their service, could a judge step in and use the rule of wrongful interference to imply a legal duty for them to cooperate with you?
It certainly makes you view that accept button a little differently, doesn't it?
It really does. It all goes back to the recipe. Are you promising to bake the cake, or are you just waiting on the flour? Thank you for joining us on this deep dive. We'll catch you next time.